We're probably going to spend most of the time on the first couple. And we can kind of break this down in quarters here after we talk about the legal planning. I'll kind of open it up for some Q&A. Just keep in mind that if you have a question that's very specific, I might have to tell you that, hey, happy to talk with you later about that because we'll need more details. But yeah, we'll do a little bit of Q&A back and forth on those things. All right. And just to gauge the audience here, by the raise of hands, how many of you are here for someone who is under the age of 15? Okay, a couple new families, and if you're not raising your hand, I'm assuming that you are for 15 and older. And how many of you are actually from here in Minnesota versus other states? Okay, thank you, hosts, essentially, basically. But everyone else is from around the country. So while I'm going to be talking about Medicaid and certain things, keep in mind that each state has their own rules and programs. So again, I'll talk about it as specific as I can, but I can't go over every single state. And how many of you, by the raise of hands, have set up any sort of legal plans, like setting up a will or setting up a trust, things of that nature? How many of you have a special needs trust? Who just raised your hand? Do you know what type of special needs trust you have? Okay, we will go over that, give you more clarity so that you know what the pros and cons are of what you got. So, for those of you who did not raise your hands having any sort of plans in place, fear not, I do have some good news for you. And that is, the state you live in has a plan for you. However, I do also have some unfortunate news for those of you who have not done any planning. And that is, the state you live in has a plan for you, okay? If you don't have a plan in place, the state will decide how your assets are to be distributed, who they are to go to, and they will appoint guardians over any minor children or adult incapacitated children. We probably don't want to leave those things to the government to make those decisions. You probably have your preferences. So it's important to put those things down in writing. And just by the raise of hands, has any group come in that has not received an info guide? Any? Perfect, thank you. Okay, so the first important document to have in place is a last will and testament, otherwise known as a will, okay? A last will and testament is a legal document that basically states you exist. You have things. Where would you like them to go? This is also where you would list who is to serve as a successor guardian over any minor children or adult incapacitated children. Now, in the documents that we create with families, we also list out anyone who needs to be excluded from serving in that role. If you don't know what I'm talking about, congratulations, your family's perfect. But for some of us, in our family tree, we may have a bad apple here or there. Someone who may look at your child as a paycheck. Might be a good idea to exclude them from serving in that role, okay? It is a document that is fairly easy to create. So if you're looking at the DIY route on these things, it is something, just for transparency purposes here, it is something easy enough that you could go on the internet, you could find a template, download it, fill it out, sign, have it witnessed, voila, okay? Now, having a will is better than having nothing, but if you only have a will, then a will is a public document. So upon your passing, it does go through the courts. So anyone can see what you had and where it's going. And that gives the opportunity for any creditors, debtors, anyone to come in and put a stake on what they think is owed to them, okay? Just by the raised hands, how many of you have ever dealt with probate? Raise your hand still if it was fun. No? No one? That's a shock. So, for those of you who don't know what probate is a division of the court. And their job is to reassign your assets to go to who you want them to go to. But they don't do that for free. They usually take a percentage of the assets for doing that job and a fee, okay? And because many people fail to plan, it can take a while. Going through that process, it can take months. Sometimes, depending on the complexity, it could be a year or two, okay? So if there's anyone that needs to get those assets right away, yeah, they're gonna have to wait until the whole probate thing has been resolved, okay? So any asset that you have that doesn't have a beneficiary, a house, some checking and savings accounts, some investment accounts, those things are gonna have to go through probate, okay? So that's an issue. Another issue is you can't list your loved one by name as a beneficiary to receive anything, because if you do, then that can affect their eligibility for government benefits now or in the future, okay? So we're gonna solve a couple of those problems with the second important document to have in place. And that second important document is a revocable family trust. If you know it as a living trust, same thing, okay? A revocable family trust is a document where you can state who is the trustees and managing the assets, who you want as the successors upon your passing, who is to be excluded from serving in that role, as well as who's to receive those assets, who's not to receive those assets. It is a private document, so it does not go through the courts. That's the reason why you get a revocable family trust, so that you can retitle your assets into the family trust, and upon your passing, those assets avoid probate. So it avoids probate. Think of the revocable family trust like if you fly and you have TSA pre-check, going through, you don't have to take the shoes off, you don't have to take all the stuff out the bag, you just kind of zip on through. That's having a revocable family trust. Whereas the will only is having to go through, take the shoes off, and all that stuff. Except if it was like probate, it would be like the TSA agent at the end of the security belt taking your wallet and pulling out a 20 and just giving it back to you as if that's totally okay to do. That's kind of how it works. So, whoops, there we go. So, in most typical family situations, having wills for each person and having a family trust for that couple or those people is sufficient because it bypasses the probate, quick asset transfer, and you can change that document at any point in the future. But if you only have a will and a family trust, there is some downside, and that is, well, the assets are still yours, so it just kind of comes with the territory that they're still subjected to creditors and lawsuits. Sometimes people think that I'm putting my assets into my family trust, so therefore they're protected from lawsuits. No, that's not the case. It's revocable, so it's deemed as yours, so therefore it's still yours, subjected to lawsuits the way it would be if it wasn't in a trust, okay? It is a little bit more of a complex document to create, so as far as the DIY level, it's not easy, it's not, I don't want to say it's hard, but medium hard difficulty. But if you put some time and effort in, you could create it. And you still cannot list your loved one by name as a beneficiary. Because if you do, it will get them kicked off their benefits. Those assets could be going to the state for payback for services provided, those things. We'll go over that more here in a second. So the third important document to have is a special needs trust. So a special needs trust, the idea here is that it is a trust separate from yours. It is designed for the benefit of your loved one who has a disability. And those assets do not affect their eligibility for government benefits, Medicaid, not going to the state for payback, and protected from lawsuits against the individual, okay? The downsides, from a DIY level, it's a complex document. Most typical estate planning attorneys do not know about disability and special needs law, and they don't draft them properly. We'll go into that here more in a second. And I guess the other downside is that your loved one cannot have direct access to the funds. That's what helps protect them. It would be managed by someone else. And for some of you, maybe you would not even entrust your loved one. They just simply don't have those capacities. If so, that's okay. Just know that they cannot have direct access to the funds. Now, there are different types of special needs trusts. So the first one mentioned up there is a testamentary special needs trust, and it's the most commonly created. And for those of you who raised your hands having a special needs trust, I'm willing to bet at least one of you has this. So this is where someone has a revocable family trust. Okay, they got that document, and inside of it, there's a paragraph or two. Hell, maybe there's even a whole page that says that upon your passing, a special needs trust should be created for my loved one. I argue that that's not even a trust, because what's going to happen is upon your passing, then someone still has to create that trust. Where are all the rules and provisions with it? So I argue that it's more of an IOU. You haven't actually gotten one because upon your passing, someone's still got to create it. But technically, I guess it is a legal trust. And the problem with it is that you can't leave anything to it while you're alive. And you hope that it's constructed properly, and oftentimes it isn't, where there's Medicaid payback provisions put in, and it says that it can only be used for certain types of expenses. So if you have that, I commend you for putting your best foot forward, but there may be some opportunities for improvement. And that's where the second trust comes in, mentioned up there, and that is the third-party, separate, irrevocable special needs trust. I'm not going to refer to it as that whole name all night. I'm just going to refer to it as third-party special needs trust. Okay? The third-party special needs trust is the least restrictive trust. It is a trust separate from yours right from the get-go. It will have its own tax ID. If it's drafted properly, it will not have Medicaid payback provisions. It will not have any government regulation or oversight telling you what you can and can't use those funds for your loved one's benefit. Anybody can put anything into this trust except for your loved one. So if your loved one has assets, whether it's through a legal settlement or assets that they accidentally inherited directly, those assets cannot go into it. This is from mom, dad, grandma, grandpa, whoever. Okay? Let's see. And then there is a first-party special needs trust. So if your loved one has a legal settlement, someone who gets injured, wins a case, is awarded a lot of money, but they need their health care benefits, well, they have too much in assets. They're not going to qualify. They're going to have to use all that money to pay for those expensive health care costs. Well, back in 1993, the government came up with an idea that, hey, we will create this trust where if you put the money in, you can remain eligible for your government benefits. But there are some restrictions. It is a government-regulated trust, so it can only be used for certain expenses, and upon your loved one's passing, whatever's left in it will go to the state first to pay them back. Only your loved one's money should end up going in there. And then there's what's called a pooled trust. So this is where it's managed by a third-party organization. I would view it as kind of a last resort. And what I mean by that is, if you have people in your life that either now or in the future are going to be able, and you trust them to manage those assets for your loved one's benefit, I probably wouldn't do the pooled trust. But if you don't foresee anybody who would be able and willing to manage things, then you could turn it over to an organization. The downside when you do that is you give up the control of the assets. And oftentimes you have to go groveling to them, requesting permission to get the funds out. And they can deny those requests if they want. So again, if you don't have anyone, it could be a good last case resort. And then there's what's called a Miller Qualified Income Trust. So if the person has income from a disability policy or so, then they can transfer that money in because there is income limits that Medicaid has. By putting the income into that trust, it makes it exempt. It doesn't count against them for qualification. Let's see here. Okay, real quickly, I just threw a whole bunch of very boring information at you. What questions does anybody have? Yes?
What would be the first step? Like, I'm sitting at my desk, I have to sit there and stare, and I don't know that initial step.
So,
I have a 6-year-old.
okay. So, the 3 important documents, possibly 4 so far, are the will, the revocable family trust, and the third-party special needs trust. Getting those things in place. Now, as far as attorneys, I'm not here to solicit, I'm not trying to do that. Just doing your due diligence, shopping around, and making sure that an attorney actually knows what the heck they're doing when it comes to disability and special needs law. Because oftentimes, your regular estate planning attorney will create that testamentary trust, which is more like an IOU. It doesn't actually exist yet. Whereas if they actually knew, there's a lot of different ways you have to tell the government to kick rocks and not get access to your assets. And 1 page, 1 paragraph is probably not enough to do that. A properly drafted special needs trust should be about 10 to 30 pages long. So, do your due diligence, shop around, make sure that it's the right person, the right people. And yeah, you can have as many special needs trusts as you want as well. You know, mom can create one, you know, if mom and dad are divorced, mom can create one, dad can create one, grandma, grandpa, whoever. Each trust is designed with its own agenda of, you know, who that person wants as successor trustees, who they want excluded, those types of things. I'll get to you in a minute, Karen. Yes?
What, if you have a family trust, a revocable trust,
Yep.
what is the difference or the benefit of having a special needs trust on top of having a family trust?
So with the revocable family trust, in a typical family situation, you could leave those assets to all your kids, no big deal. But if you have someone who is going to need Medicaid, going to need SSI, you want them to be eligible for it, or they already have it, you can't leave those things to them. Because if they get more than $2,000 to their name, then they will get kicked off those benefits, and any Medicaid-related services that you have been receiving, it's nice that you haven't had to pay out of pocket for those things. But don't think for a second that the government has forgotten what they have provided you, because they have not. In some bland government building, on some computer that's probably 10 years old, there is your loved one's profile. And they keep a running tab on what they provided. So if your loved one comes into $25,000, and all of a sudden, well, they have a tab of $50,000, that $25,000, whoop, just going to go to the state. And then you'll have to go through the whole requalification, reapplying process to be able to get them back on their benefits. So in your family trust, instead of leaving things to your loved one, you're going to say, you know, whatever you want left to them is left to the name of their special needs trust. Okay? That's how you would properly put those things aside. Does that help answer the question? Perfect. Karen?
Okay, so you were saying that we can have multiple trusts set up for the same individual.
Yep.
You can have multiple individuals put it to one trust?
Anyone can leave anything to it.
Okay.
So again, if you have like a divorce.
Their estate to the
Yep, correct. And the third-party special needs trust is an asset protection trust. So I'm not telling you what to do or not to do, but if you happen to either yourself or have a family member who is getting a little bit older, well, what are your plans for taking care of that individual? Is it going to be them living, you know, with a child or a nursing home, assisted living? That can get expensive. I don't know how many of you have had experience with that, but nursing homes, in-home care, group homes, that can be anywhere between $3,000 to $10,000, sometimes $15,000 a month. So that can really drain away people's assets. And from time to time, I'll have someone that's a little bit on the older side say, I have Medicare. I'm covered. Why are you laughing, Liz?
You'll get the $2,500.
That, but Medicare doesn't cover long-term care. It does not cover group homes, nursing homes. I think you got 90 days of hospice. That's it. So,
And 2 8-hour visits.
thank you.
Only 2 8 hours.
There you go. Yes, 2 8-hour visits. So because of that, I have not forgotten about you. So you can put your hand down. Don't wear yourself out. So essentially, yeah, you're either going to have a long-term care insurance plan, which obviously at that point no one's going to insure you, and those things can get expensive. And you might feel like I'm putting a lot of money into kind of a black hole. What if that person doesn't need that type of care? So it could be considered a waste of money. Or you have to pay out of pocket, or just like your loved one, qualify for Medicaid. If you've ever heard of someone having to spend down their assets to qualify for health care, this is it. They are just like your loved one, having to be below $2,000 in assets. And it's not one of those things of, oh, I'm going to be so sneaky, and I'm just going to give everything away right now to my kids. It doesn't work like that. The government can look back up to 5 years. In some ways, they're stupid. In others, they're not that stupid, okay? So you'll get penalized. You won't qualify. You'll have to use those assets to pay for that type of care. What if ahead of time, that person or those people transferred their assets to a special needs trust? That's not considered theirs, but they could still have total access to it. So we're focused so much on one side of the generation timeline that sometimes we forget about the other side.
But if you leave some, the special needs trust is almost like an individual. So your family trust would then designate the funds, or they have to go hand in hand.
Correct. Yes, that's how they kind of come together.
So if you have Molly and Sarah as your children and Evelyn, then Molly and Sarah get their portion and they're not a special needs child. Evelyn is, and she has a trust associated with her assets.
Correct. Yes. So in your family trust, you would indicate that special needs trust you want those assets to go to. Obviously, it has to be created though. But think of that special needs trust like a business, or it's its own entity. Okay, so if you opened up a business, you get a tax ID, you get a license, and then you could go to the bank. You can open up a checking account in the name of that business. The trust is no different. It has its own tax ID, like what your Social Security is to you. Tax ID is for that trust, and you could put whatever you want into it. Property, real estate, bank accounts, investment accounts, whatever. And it will not be considered assets that belong to any individual. They belong to that trust.
I'm from Pennsylvania,
Okay,
so some of it's a little bit different.
tell me more.
The thing about, she's only allowed to have $2,000. But I did find out, because I'm old, my husband and I are both on Medicare. Once one of us is on Medicare for 2 years, which will be my husband next year, then she gets Medicare. She'll get the same amount as whichever one of us gets more Social Security.
Lisa, I appreciate what you're saying, and you are beating me to the punch of what I am going to be discussing here.
And then after that, the $2,000 doesn't matter. She can have as much money as she wants.
Unless you still are getting Medicaid waiver services, which I'll get into in 1 second. Oh,
This came from the Social Security office.
garbage in, garbage out. It's unfortunate that such a large institution has so many incompetent people, and yeah, that's the danger. So I'll go over that part here in a second and how that relates. But as far as any sort of Medicaid services, okay, that's great if someone gets off of Medicaid. But again, the state hasn't forgotten what they've provided. So if you still leave it to them, the state's going to come in and pick up their part.
Now with our house, it's paid for. So before, in our will, which we have to change again,
Okay?
But now we've changed it because a lot of other families in our community are doing this. Our house is paid for. We're gonna not leave the house to her. She's gonna live in the house. And we will have her caregivers. And my son will be in charge of the caregivers and in charge of any of the financial stuff. But so we need to leave the house in the name of the Special Needs Trust.
If you have a house and you want to leave it, you can leave it to whoever in your will. But the problem is, if it remains in your name, then it will go through probate first. So again, the government will take a percentage of the asset value for simply doing their job and a fee. But after that, yeah, whatever remains will belong to whoever it is. You can leave it to your kids. You can leave it to a special needs trust. Ideally, though, if you have a family trust, you retitle your house into it so that it avoids probate. Correct. So yes, there's a couple things there, and Lisa, I'm more than happy to schedule a complimentary private meeting with you to discuss that further, but you're on the right track. You're just beating me to the punch on some of these things. So that's a special need. I know there was one other hand, I think. Maybe. No? Yes?
If we only have one child with special needs, do we need the revocable family trust?
To avoid probate. Because if you have a will, some people think, okay, I'll just leave it to the special needs trust from the will. Great, it's still going to have to go through probate first. Whereas if you retitle it into the family trust, it avoids probate. That's why you don't have to be a millionaire or a billionaire to have a family trust. The idea here is to avoid probate. Again, I didn't see any hands go up saying it was a fun process going through probate, because it's not. Let's see here. Guardianship. So, guardianship can be a touchy subject, and I have no problem confronting controversial matters. So, those of you who raise your hands because your child is under 15 or under 18 for that matter, I guess, that's great. You can make decisions. But please, mama bears, do not claw my eyes out when I say this. But when your child turns 18, you no longer have the legal right to make decisions for them. You just don't. They are an adult. There is no exemption in the Constitution for someone who has a disability. So, if you need to retain that right to have access to medical records, make medical decisions, protect them from financial exploitation, you need to petition your local county court for guardianship. Guardianship is what gives someone the ability to make decisions for someone who's unable to. Now, guardianship has been abused forever. It just so happens that probably the past 10 years, it has become more, and people become more aware of the situation. There's the Britney Spears conservatorship. There's the, what was that Netflix movie? I Care, or I Care a Lot. Anyone see that movie? Had the crazy Gone Girl chick in it. Yeah, it was about this lady who basically becomes a guardian over all these old people and basically robs them blind of all their stuff. It's a great ending if you haven't seen it. But if you laugh, yes, I have that morbid kind of sense of humor. But yeah, there is abuse, okay? Yes?
So let's say you happen to have sole legal custody over a child with special needs.
Yep.
Does that play, does the court sometimes honor that after 18, or they just start fresh? I'm sure that sounds more like a lawyer question maybe, but like, what have you seen in general?
So custody is all about having, well, custody of minor children.
Yeah.
At 18, they're an adult. So you need to go through petitioning the court for guardianship of the individual, okay? Now, guardianship is not for everyone, okay? But it still has a purpose. I'm not a fan of showing a couple of examples and saying, that's why guardianship is bad for all. You know, are there good cops and bad cops? Yes. So just because there's a couple, you get rid of cops altogether? Probably not, okay? Don't throw the baby out with the bathwater, okay? So I'm not here to tell you which of these things is appropriate for you. You're gonna have to figure that out now or in the future when they do turn 18. I'll give you a scenario though. So let's just say that your loved one is walking around the mall, strolling around the mall, all by themselves. And they come across a cell phone rep at one of those cell phone booths. And they say, hey, I got this brand new shiny iPhone 5000 or whatever at this point, I don't even know. It can be yours, no money down. All you have to do is sign this piece of paper right here. You know your loved one better than anyone. You tell me, what's the likelihood that your loved one is going to understand the gist of what they're signing and possibly do it because they want that brand new shiny phone? If the answer is that they don't understand what they're signing, and they might do that because, yeah, they want that phone, guardianship might be the route to go. Because if you had guardianship and they sign that contract is void, okay? Because they are not allowed to sign contracts, okay? That is something that you are taking away. You know, with guardianship, we are talking about taking away some civil liberties from someone. Can your loved one get married if you have guardianship? Yes. Just like a 16 or 17-year-old, got to have, a parent sign off on it. Same thing, got to have the guardian sign off on it. Can your loved one retain their right to vote? Yes. They can have that as a request during that guardianship hearing in front of the judge. Can your loved one hold a firearm? Probably not on that one. Can your loved one drive? The answer is yes. Anyone here, Illinois? No? Yes? Full guardianship? No. Limited guardianship, you can retain your ability to drive. So, just like a 16 or 17-year-old, got to pass the driving test, got to have mom, dad sign off. Same thing, okay? And I think what oftentimes gets lost in the negative guardianship connotation is that isn't your underlying goal to one day have guardianship removed? Because that will have meant that your loved one has grown and developed so much that it's no longer needed? That's what we oftentimes lose sight of. And I'll get a family from time to time, and I get they can be emotional, and they'll start getting teary-eyed thinking about their loved one being 18 and they need guardianship. Subconsciously, a lot of parents, they kind of stop pushing for that growth and development just because they have the guardianship. It's just something that connects there. No, continue to push for their growth and development. Continue implementing them in programs and continuing to do those things. Because if you stop, then yeah, guardianship is going to be there for the remainder of their life, and you're not going to know how much they can grow and develop. So that should not stop you at all. Okay? Continue to push for the guardianship.
We're being realistic. We will always have guardianship over our daughter because she's never going to be able to do that. The biggest thing with us was, after she turned 18, I started having trouble talking to the pharmacy, talking to the doctor's office. Well, we need to talk to Jennifer. She's not verbal. She does not understand it. She, was able to stay in school till she was 21. She's 29 now. She could have had an accident at school and then hurt. They could send her to the hospital, and nobody from the school or the hospital would need to call me. I would have no clue what happened. So with the guardianship, they would have to
Do you provide that paperwork to each of those entities along the way so that they would have access to it, so that they would put something in?
I keep a copy in my car, and the judge who has a special needs daughter, she said, keep a copy on your phone.
So you went, you got a lawyer, and they filed something in the counter.
Let me get some things clarified here as we're having these little powwows here. Okay, one thing just brought up. Do you need an attorney? I like to be transparent. If someone is going to fight you over the guardianship, including your own child, then it may be a good idea to retain legal representation, okay? But just know that it is something you can go the DIY route. You do not need to retain an attorney to do it. Now, if you're in a position and you just don't want to deal with it, you don't want to worry about screwing things up, sure, you can retain legal services to do those things for you. We do those things all the time. But just know it is something you can go the DIY route if you want to. And then, yeah, once you get that official guardianship paperwork, it's a great idea to keep a copy in your car glove compartment in case of emergencies. Provide a copy to schools, doctors, therapists so that they have it on file so that you can have access to medical records, be able to assist in those things, assist in educational decisions, all those types of things. Okay? The alternative, and I'll kind of connect it to what you were about to say there, Lisa. The alternative to guardianship is medical and financial power of attorney. These are legal documents that actually each and every person should have. These documents give someone the ability to speak on your behalf if you are unable to speak for yourself. Okay? It's better than having nothing, but power of attorney doesn't really hold up in court. It is flimsy at best. And what I mean by that is some organization, some doctor, whoever, they can simply choose not to acknowledge your power of attorney. Because the first hoop you have to jump through for that to even be a possibility is, can my loved one understand the gist of this document? If they can't understand it, you can't do it because they are the ones signing it. And even if they do, they could amend it, they could change it, they could tear it up right away. So if you are in a doctor office and you want them to get an immunization, something that's not life-threatening, and maybe your loved one is scared to death of needles, and they're saying, no, I do not want that. And you're saying, I have the power of attorney, and I want them to get this. They're not going to listen to you. They're not going to listen to you. They're going to listen to your loved one because they're speaking for themselves, and they don't want to fear violating that person's civil liberties and getting sued. They'll do it. Guardianship is more ironclad. It is court appointed. Yes, it is honored. Yes.
So in our state,
What state?
Washington,
Okay.
guardianship's not one and done. Every 3 years, the paperwork has to be filled out, it has to be redone, all these things have to be submitted.
When it comes to guardianship, each and every state, each and every county will have its own rules, its own paperwork. Some places require you to redo it every 3 years. Some places require a report to just simply be submitted every 3 years or 1 year. Okay? It just depends on your respective state and the county that you reside. And then if you were to move, you do have to petition that new county you begin residing in to get guardianship. Oftentimes there's some reciprocity where you provide the guardianship paperwork from the other court, and it's a fairly simple process to transition it. But just know, if you do move, you do have to do that. I think 1 or 2 states have it where even if you move to a different county in the state, yes, you do. I can't remember which states it is. It's mostly if you move from one state to another, then you'd have to do it. Keep this in mind as well. With the guardianship, on one hand, it is a big and important responsibility. On the other hand, it's not like you are expecting that person to babysit your loved one 24/7, hold their hand everywhere. The guardian is simply responsible for making sure that your loved one has a roof over their head, that they have food on the table, they're getting to their doctor appointments. Okay? So it's not, everyone has their own circumstances. Some people might require more care, but that guardian is simply responsible for kind of overseeing and administering things, getting caregivers, making sure that everything is done correctly for your loved one's benefit. Okay?
Do you have to wait for them to turn 18 before you can file for guardianship?
Some counties, some states allow you to file before they turn 18, 17 years and 9 months or so. A lot of states have stopped that because they're incompetent clerks. No offense to anyone who's a court clerk here. They will file it, and when you filed it, they were a minor. And they don't have the presence of mind to figure out that you're doing guardianship for an adult. They just look at, they're a minor. Guardianship for a minor, which will end at 18. So what's the point? So oftentimes you have to wait until they're 18, but again, it depends on the state and the county and what their respective rules are. So usually when you have to wait at 18, there will be a little bit of a window where they're 18 and an adult, and you don't have that authority. So you cross your fingers, nothing happens, and get it done as soon as possible. So thank you. Thank you, Liz. Is there a question over here, Tracy? Do you have a question or something you wanted to?
What, my experience?
Oh, yeah, I thought you were about to say something.
We thought it's going through an attorney is best, just for the little hang-ups, the DYI stuff sometimes get you
Yep.
hung up through the process. Yeah. Because I'm sure there's documentation that has to go with the guardianship paperwork as you, like medical paperwork and things like that, but you know.
There's a doctor report, a petition. Every county has its own respective list of required papers.
And then the other thing, I'm so sorry. Okay, the other thing, the last one. If I'm the guardian and I died, right, is the guardianship transferable through the trust, or does the next person who's going to be responsible for my child have to then apply for guardianship?
That's where one of your forms that your successor would be doing is filing your will. Because your will, if you remember, is where you list out who is your successor guardians or who you don't want serving as a guardian. They would provide that in reference to, yeah, see, I'm the person as stated in the will, shows that, yeah, they're the person that's supposed to. You can exclude just about anyone from being a guardian. The only people that you can't are the biological parents. So for some of you, crap.
Once that guardian is named, then what information would they then provide to the doctors, the whatever, if they're going to school still or whatever, would they provide then the will and the guardianship paperwork, or would that just give them permission in the interim to be guardian until they are able to get guardianship?
It wouldn't be an interim thing. Again, you could try it, but some places will simply choose not to acknowledge that because it's not technically legal. You could try it. Otherwise, they're going to have to do the same guardianship process as you, except that they would just be adding the will as another document to reference that they are supposed to be that person. Correct. And you can have multiple guardians. You can have co-guardians, okay? So it's not just one person. You can have two people, okay? No, you cannot have four. No, four is too many. Let's see here. Okay, so quick review. No plan, government's deciding things. First document, having a will. Second, the revocable family trust. Third document, special needs trust. And just depending on the situation, it may be multiple special needs trusts. And then as well, having the medical and financial power of attorney for yourself, and then either that for your loved one or having guardianship. How many of you have heard of supported decision-making agreements? Anyone? Okay, so I won't project my theory on how this came about, but it is kind of like a power of attorney where the person does have to understand what it is, and it's giving someone the ability to help them with decisions. But just know that state statutes do say that you can't, it's not something you can hold up in court, and you can't hold anyone liable for following things under the supported decision-making agreement. So it's kind of like a power of attorney. Some states have been coming out with recently. Okay, government benefits. So there are cash benefits. There are medical benefits. And oftentimes, we refer to one of these programs when we actually mean a different program. So we're going to get those things clarified today. So there is SSI, SSDI, retirement survivor benefits, Medicaid, Medicare, micro boards we'll briefly touch on. So in a nutshell, SSI is a monthly benefit that's paid out by Social Security. for individuals who have had a disability prior to the age of 22. Okay? And they have to have limited income, limited assets to be able to qualify for it. SSDI, or Social Security Disability Insurance. That is what's paid out to someone who has actually worked and paid into Social Security, and then they have become disabled and unable to work. Okay? So if your loved one is not working, has not ever worked, then it's going to be SSI unless a parent gets SSDI, then they could as a minor, but we won't get into that. And then there is the Disabled Adult Child Benefits. Lisa, stealing my thunder here. So that is where an SSI recipient begins collecting off of their parents' Social Security amount. We'll go over that here in a second. And then there's retirement survivor benefits. So upon reaching 62, 65, whatever, and you've paid in Social Security, starting to claim Social Security, that's what that is. And then the survivor benefit. There's a little added amount that goes to your loved one's benefit upon the parent passing away. So there's SSI, like I said, pays monthly benefits to disabled adults and children who have limited income, resources to meet food, clothing, and shelter. There is SSI for children, and there's SSI for adults. I don't know how much I'm going to spend on the children's slides here. Just know that in order to qualify for SSI, when your child is a minor, Social Security is going to look at your income and assets as the parents as well. And for what it's worth, if you don't qualify, fear not, you're with 95% of the population, basically. Okay? The parents have to have minimal income and assets in order for them to qualify. Okay? Oftentimes, people are waiting until their loved one turns 18, because at 18, they are an adult, and they will not consider your income and assets anymore, or they shouldn't. You should not be disclosing those things because it's not part of it. Okay? The max amount monthly that SSI pays out is $943 a month. Some states have some supplemental amounts that they tag onto it as well. And on one hand, the government thinks that your loved one can live off of $943 a month, and that's kind of ridiculous. On the other hand, if your loved one lives to the age of 80, that's about $1 million in cash benefits. So it's not nothing. It can definitely help supplement what you envision, what you want for your loved one. And like I said, there's the financial eligibility, there's also the medical, we'll get into that. Let's see. Who is a child for SSI? A person who's not married, not head of their household, under 18 or under age 22, and is a student regularly attending school. Ideally, though, you want them, if they're 18 or older, to be on the adult SSI. Let's see. Financial eligibility based upon the household income until the month after the child's 18th birthday. So if your loved one's turning 18, you can apply for SSI right when they turn 18. It might be a good idea to wait until the first of the following month so that some minion in their administration does not get things mixed up and include the parent's income and assets. Let's see. When you're applying for a child, they're just looking for the diagnosis. So as far as medical, you'd qualify. I mean, everyone here, Moet Wilson, it is on the compassionate allowance list. So medically, your loved one will qualify. It's all about the parent's income and assets as well as the kid's income and assets. Let's see. As far as the amount per household, I know it's kind of in small print. You can find this online. And it shows the breakdown of one parent in the household, two parents, how many kids, how much you have to be under in income to qualify.
Is that reportable income?
Yeah, there's different types of income, some that are exempt, some that are not.
Parent stuff, you know?
What was that?
Does paid parent included in this? Because that's not taxable.
I can't remember the list of what is exempt. It's happy to have a further conversation with you about it. We'll go over that. But yeah, so they are able to qualify if they meet those rules. Like I said, meets the definition of disabled, and yeah, has lasted at least 12 months or expected to last at least 12 months, or can be expected to result in death. Let's see, child SSI recipients can expect to receive redeterminations, continuing disability reviews at least once every 3 years. So basically, a state agency will make sure that the person still has a disability every 3 years so that they can qualify. And just continue to provide evidence, records, things like that. And if your loved one has SSI as a minor, it's actually a better idea to go in a couple months before they turn 18, go into Social Security, and speak with someone about transitioning them. They're already in the system. It is slightly quicker to go in and work with someone to get them transitioned to SSI as an adult. They're already in the system. You're one step ahead of everyone else. SSI for adults, though, like I said, they no longer consider the parent's income and assets, but the definition changes as far as what qualifies medically. It's not about just simply having the diagnosis. It's about, is this person able to hold a bare minimum job that could provide them a bare minimum standard of living? Like, okay, you have autism, great. But if you're so high functioning that you're capable of doing that, you're not going to qualify. Now, in your case, I do believe that with Moat Wilson, I think it was put on 2 or 3 years ago on the compassionate allowances list, which is almost like your flash pass. You kind of zip through and are able to just get awarded it. Oh, there's your fancy income thing right there. Earned income, unearned income, at least some of the things that are considered part of it. You want to take a picture before I change it? You got, okay, perfect, thank you, Liz. All right, so like I said before, $2,000 is the max amount of assets. So cash, bank accounts, investment funds. A person is allowed to have one house in their name and one car and still qualify. Now, for prudent investor reasons, or just prudent financial reasons, still not a good idea to probably have it in their name when you could have it owned by a special needs trust or your trust or whatever, okay? And you can have up to $100,000 in ABLE account, which I'll go over here in a second. Let's see here. Like I said, it's not about if the person's disabled, it's, does the disability keep the person from earning a salary to support themselves? Can they work? Now, you can apply a couple different ways. You can apply online, you can apply in person, you can apply over the phone or get an appointment scheduled. Social Security does recommend applying online or phone contact. How many of you have gone through SSI and have SSI for your loved one? How many of you had a good time doing it and there were no issues? Oh, okay. Well, yeah. The percentage of people that get approved has increased. It's up to about 35, 40%. And it's not because 60% of people just simply don't qualify. It's just a good business strategy. If you reject a whole bunch of people, there's going to be a whole bunch of people that give up and quit because they are frustrated with the process. And every person that does that, that is a victory in the eyes of Social Security because they don't have to pay out. If you do get rejected, know that you can appeal it and you can apply over and over again. Okay, there's no limit to that. Okay, but let's try to put your best foot forward and get approved the first time around. Okay, let's see here. Oftentimes when people are going through the process, applying online or whatever, unknowingly, they will provide the bare minimum information. Who's their current doctor, who's their current therapist, that's it. Probably a good idea to list out any and all previous doctors, therapists, anyone that would have medical records on the person, okay? And in your guys' case, probably a good idea to show the genetic results with the Moat Wilson syndrome, because again, it's on the compassionate allowance list, which is like your flash pass, to get approved. Like I just said. Let's see. Yeah, as of 2022, on that list. And also meets, so there's what's called a Social Security Blue Book, which is kind of like a manual that Social Security uses. And it goes over all different conditions, diagnoses, and what severities someone has to be at in order to qualify. So in addition to Mowat-Wilson, it also meets the intellectual disorder, development disorders in infants and toddlers, if you're applying for kids. But as far as increasing your chances to get approved, like I said, a lot of people just do the bare minimum, not knowing it. Put together any and all medical records, data, research, any letters that anyone is able to write on your loved one's behalf, advocating for them, talking about, sadly, the things you don't want to hear, the things that prevent them from being able to have a job that could provide them a bare minimum standard of living. Okay? Any and all that stuff's going to increase your chances of getting approved. Let's see. So those of you who have SSI, raise your hands again. Okay, how many of you are getting at least $940 a month? Okay, if you're not getting somewhere close to that, it's probably because you are not charging your kid rent. Sounds stupid. I'm not going to charge my kid rent. Well, SSI is for two things: food and water and shelter. And they're going to ask you if they're paying rent. If you say no, well, then obviously you don't need half this money. So oftentimes people will only have like $500, $600, $700. If that's your case, create a rent contract saying that you're charging your kid $600 a month in rent, saying that it's the same amount that you would charge anyone, so they're not getting a hometown discount. Submit that to Social Security. You should be able to get your SSI increased to that maximum amount. Now, if your loved one is working, income can slowly start to affect how much they're getting in the SSI. Because again, the SSI has those income and asset limits. Let's see here. What time are we at, Karen? How much time I got? 30 minutes? 8 minutes, holy crap. Okay, again, happy to schedule complimentary meetings, do the feedback forms, fill that out. Like I said, you can appeal things. And SSDI, that is for someone who's actually worked, paid into Social Security, and becomes disabled. If a parent becomes disabled and their child's a minor, then you can get SSDI benefits. Now, the part that Lisa over here was talking about earlier is the disabled adult child benefit. So let's see here. So, typical family scenario: child disabled from birth, not eligible for SSI during minority because of parents having too much in income or assets. At 18, they apply for SSI, get approved at some point. By the way, expected wait time for SSI, keep it around a year. Yeah, it can take a while, okay? But let's just say your loved one's on SSI, and then you retire or start claiming your own Social Security. Your loved one is eligible for 50% of what your Social Security amount is at your full retirement age. So, if you retire and you start collecting $4,000, last I checked, 50% of that is $2,000. $2,000 is more than $943. So, your loved one will get bumped up from getting $943 in SSI to the disabled adult child benefit of $2,000. And the disabled adult child benefit doesn't have those income and asset limits. Okay? So if they're working, great, they can work and not have their disabled adult child benefits reduced. Upon the parent's passing, then they can get an extra roughly 25% added onto it. Okay? So now we're making some headway. Now we're able to plan a little bit more with that type of income. Okay? When you apply for your Social Security, on the application there's a part where it asks if you have a disabled adult child, and you can select that. Lisa, did you go through that? Do you remember?
I'm not collecting Social Security yet.
Oh, I thought your husband? No? Not yet. So I'm basically telling you what to do. So yes, when you apply for your Social Security, there's a part on the application that says that, do you have a disabled adult child? There you go.
But now, because I will get more in Social Security than my husband, so
If you are trying to figure out between yourself and the other biological parent who's to claim off of, you're going to have to do a little bit of math, figuring out who's going to be more beneficial. If one person is going to get more, but they're not claiming for 8 years. What's the difference that you're going to miss out on? But if it's, within a couple months, it would be better to claim off of the parent who's going to be getting more in Social Security so that your kid can get more. Let's see here. Medicaid, Medicare. Medicaid is your state health insurance, okay? It is your state health insurance that has those income and asset limits. Medicare is your federal health insurance. You usually get Medicare upon reaching the age of 65, okay? Medicaid, like I said, has those income requirements, provides typical health services, just like Medicare, but not as many doctors, providers choose to accept Medicaid, okay? Now, when you get that disabled adult child benefit, your loved one will undergo a transition where they're not only getting Medicaid, but they're getting Medicare, and they'll be what's called dual eligible. Also, before I forget, if you like your private health insurance plan, you want to keep your loved one on it for as long as possible. People think, oh, at 26, they have to come off. Nope. Past 10, 15 years, there's been legislation that allows someone to keep their disabled adult child on their health insurance plan for life. If you're willing to pay the premiums, you can keep them on. Some states even have programs that allow you to get reimbursed for what you pay in for that private health insurance policy. Because that private health insurance policy is your primary, Medicaid is the backup, okay? Let's see here. Yeah, so there's some things that both offer, things that others do not. Like I said, Medicare does not provide long-term support. That is Medicaid, okay? Medicaid has Medicaid waiver programs. Raise of hands for those of you who have minors, how many of you have Katie Beckett? Do you know what Katie Beckett is, or the Medicaid waiver? We can talk. So, if you don't know, the Medicaid waiver is this additional set of supports and services for someone who has a disability. It provides things such as occupational therapy, speech therapy, behavior, medical equipment, paid caregiving, respite. Each and every state has its own rules. Some states allow you to be a paid caregiver for your minor child. Others do not. Some states allow you to be the legal guardian and the paid caregiver. Others do not. Okay? Each and every state has its own rules. But that's where it can be very beneficial to keep the Medicaid waiver even if your child's on disabled adult child benefit, which means you still have to abide by the income and asset limits. Well, not the income because it waives the income, but the assets, yes. Let's see, some states, you get approved for SSI, they'll just push you through and you're getting Medicaid. Other states, you still have to apply separately. Other states have their own income rules where you have to apply, but their rules are kind of the same, it's just technically not. Yes?
So one of the things you mentioned about the SSI is to have all the type of paperwork, letters, et cetera, that you can to speed things up.
Yep.
So right now, we're on the Medicaid waiver wait list, and initially it was 2 years, and then I called recently, and it's been a year, and they said it's another 2-year wait. So is there any tips, tricks, loopholes to speed that process up?
Take it with a grain of salt that what they're saying, don't take them fully at their word, because I've had people where, yeah, they'll all of a sudden say bigger number and then 1 month later they're approved. How does that work? So take it with a grain of salt. There's nothing that can really expedite unless their situation changes, or your situation where parents are no longer in the picture, some emergency, that can expedite. Otherwise, get on the wait list as soon as possible. If you're not on the wait list for your loved one, get on it, because the sooner you do, the sooner you can start receiving benefits, because each and every state has their own cap on the spending, and yeah, they make these arbitrary things of how many people they're willing to support at one time. So get on it as soon as possible, whether it's for your child or your adult child, okay? So recent diagnosis or so, get on that waiver wait list. That might be a PA thing. Every single state has their own waiver program. Some have more than others, some condense them. It depends on your state and what you're looking for. Given some of your guys' circumstance, some of you might just qualify for the intellectual disability waiver, others the physical disability waiver. It gets really in the weeds with that part. But happy to have a further conversation with you about it. Let's see, the states that automatically enroll, the states that you have to apply separately. Let's see here. So if you get SSI, behind the scenes, those agencies will just take care of enrolling and you'll get paperwork saying, hey, you're enrolled in Medicaid.
Yeah, our state is included in that, but it's not the same, the Medicaid that you get through SSI is not the same as the Med Waiver program.
There's Medicaid, which is your health insurance. And then there's the Medicaid waiver, which is those additional supports and services for someone who has a disability. So some people don't qualify for Medicaid. They get the Medicaid waiver, though. Just because you have too much in income or assets, you can still apply for the Medicaid waiver. You might not get full Medicaid, but you could still get the Medicaid waiver. Karen? Okay, we're almost at time. Why? Because I said so. No, just kidding. Let's see here. Yeah, Medicaid waiver provides all these different types of supports and services. Get on the wait list as soon as possible. Let's see here. Transition benefits, yes, talked about that. Microboard's not doing that part. Budget, financial planning, no, we're not doing that part, nope. Budget, financial planning, making sure that you are accounting for, what are your assets, what are your expenses, income, both now as well as in the future for what you envision for your loved one. How are you gonna pay for those things? Well, that's where there's various things that you can do. Save every penny, put money away in retirement accounts. Sometimes what people will do is when they get SSI, just mentally expect to only have $500-600 and then take $200-300, put it to a life insurance. If you envision your loved one living with you for the rest of your life, that's not your concern. Your concern is when something happens to me, then what? Well, if you have a life insurance policy, boom, there's a death benefit to do that. ABLE accounts were created by the government about 10 years ago. They can have benefits if you don't have a special needs trust. You can put assets into it. Doesn't affect their eligibility for benefits, but it is state regulated and it will go to the state for payback upon their passing first before going to anyone. Okay? So if you have a special needs trust, it really takes away a lot of the shine that ABLE accounts offer. But if you don't have one and you have mom, dad, grandma, grandpa, getting, holiday checks, birthday checks, whatever, you can put it there rather than stuffing it under the mattress. And then the final part is the lifestyle and transition planning. So let's just say you have all the legal planning in place. Great. You have all the government benefits. Fantastic. And hell, you've even done the budget and financial planning. As taboo as finances are, you did it. Fantastic. Good for you. I'm willing to bet that for many of you, your loved one couldn't care less about any of that. What your loved one cares about is at 1:05 p.m. every day they're watching SpongeBob, eating their peanut butter and jelly sandwich with the crust cut off in their favorite orange shirt. Okay? Those are the things that are important to them. If it's important to them, it should be important to us. So we create what's called a letter of intent. And it's kind of like a caregiver guide into who your loved one is. What are their likes, dislikes, behaviors, tendencies? What would any future caregivers need to know about your loved one to be able to take care of them best as possible? And you can write these things down. You can do audio. You can do video. With the clients that we work with, we create private YouTube channels. Totally private. Create audio, video recordings, showing how to operate equipment or just talking about them. And you can add on to it as you go forward. If you have that in place, along with the government benefits, the legal planning, and the budget financial planning, that is a comprehensive plan to maximize your loved one's benefits, their opportunities for growth and development now, as well as in the future. So next steps, if you can just fill out those feedback forms, tell me what you liked, all the things you hated, how you almost went to sleep to this. And there is a box if you would like. You can check it in the middle of the page. Happy to schedule a complimentary private meeting with you at a later date and time to go over this, but as it applies to your circumstances. So at the very least, you'll better understand planning and how it applies to you. If you did not get a feedback form, please let me know. Each group should have gotten one, but just raise your hand if you didn't. Otherwise, I want to thank you all for your time and want to thank the Moat Syndrome. Is that foundation or is it organization? The foundation. Thank the foundation for having me. You guys have been fantastic and hope you guys enjoy the rest of your day, and just either leave those feedback forms on your tables or you can hand them to me up here. I'll be here. So thank you.
Thank you, everybody. Just so I know, there's gonna be a little light snack again out there in the area as y'all transition to whatever your next class is.
Thank you, Liz.